we're about to introduce that we will not hear the last of on this podcast is our drag queen case. So here we go. You know what, David? I never in a million years thought that if you just rewound the clock to, like the start of the Trump era, that I was going to talk so much about drag queens. That was not on my bingo card. But here we are again. This case is called Spectrum versus Wendler. It is in the Northern District of Texas, Amarillo Division. And I'll just read you some of the basic facts of the case here from the decision. Plaintiffs are a recognized student organization at West Texas A&M and two of Spectrum's West Texas officers. The plaintiff strives to provide a safe space for LGBT plus students and allies to come together to raise awareness of the LGBT plus community and to promote diversity, support, and acceptance on campus and in the surrounding community. So this is an organization with a viewpoint. In furtherance of that mission, so again, in furtherance of that viewpoint, in furtherance of that mission, Spectrum WT hosts events such as Lavender Prom, Queer History Night, and Queer Movie Night. Plaintiffs also planned a March 2023 fundraiser at a campus event hall to raise funds for LGBT plus suicide prevention. In papers filed with this court, plaintiffs described the proposed event as a drag show open to children accompanied by a parent or guardian. The proposed event was tentatively scheduled for April 1 and branded a fool's drag race. Due to a scheduling conflict, Spectrum agreed to hold the show one day earlier. But before it confirmed the event, the defendant, Walter Wendler, stated his opposition in a letter that says, the school will not host a drag show on campus. In the letter, President Wendler analogized to another type of theatrical performance, blackface minstrelsy, to explain his opposition to any event exaggerating, stereotyping, mocking, or objectifying a person based on appearance, bias, or predisposition. And I'm reading now from the letter. As a performance exaggerating aspects of womanhood, sexuality, femininity, gender, drag shows stereotype women in cartoon-like extremes for the amusement of others and discriminate against womanhood. Any event which diminishes an individual or group through such representation is wrong. Should I let rest misogynistic behavior portraying women as objects? Drag shows are divisive, and demoralizing misogyny, no matter the stated intent. Such conduct runs counter to the purpose of WT. A person or group should not attempt to elevate itself or a cause by mocking another person or group. As a university president, I would not support blackface performances on our campus, even if told the performance is a form of free speech or intended as humor. It is wrong. I do not support any show, performance, or artistic expression which denigrates others, in this case women, for any reason. Mocking or objectifying in any way members of any group based on appearance, bias, or predisposition is unacceptable. No one should claim a right to contribute to women's suffering via a slapstick sideshow that erodes the worth of women. When humor becomes harassment, it has gone too far. Okay, David, I would read that, and if I was a plaintiff's lawyer in free speech case, and I would think, Judge, what we have here is an admission of viewpoint discrimination. If you would like to just go ahead and issue the injunction against this, I would appreciate it. But what we would really appreciate is if you would go ahead and start calculating our attorney's fees for having to file this case in the event of obvious unconstitutional viewpoint discrimination. But that is not, David, what happened in this case. What happened in this case, at least so far, is that the judge sided with the university. And I knew we were in trouble when we got to the opening segment of the opinion. And I'll read it. Free speech jurisprudence only intermittently invokes the historical analysis applied to other amendments and clauses. And it talks about New York State Rifle and Pistol Association v. Bruin, applying a text history and tradition, American Legion versus American Humanist Society, explaining that the Establishment Clause jurisprudence looks to history for guidance. Said historical analysis reveals a free speech ecosystem drastically different from the expressive conduct absolutism of plaintiffs' briefing. 1, the founders focused on prior restraints of publication, specifically political pamphlets. And 2, draft free speech clauses focused on protecting the right to speak, to write, or to publish their sentiments. Blackstone treatises extolled freedom of thought and recognized the police power to censure licentiousness, etc., etc., etc. And what I found interesting about this is this district court judge went on to essentially create his own test. Really, it nodded, David, and tell me if you think I'm reading this incorrectly. It sort of nodded towards existing jurisprudence, but really sort of went back to what I would say as an analysis, a First Amendment analysis that a lot of folks in the new right urge, which is sort of a text history and tradition kind of analysis for the First Amendment. And that does actually take content and viewpoint into account. And it was a very strange opinion in my view, because essentially what the judge did is say, wait, this regulation on men wearing women's clothing and engaging in behavior that is arguably lewd is not a prohibition on the basis of, say, content. And yet, much of the opinion, he's railing on the content, just like the president of the university railed on the content. So on the one hand, he's saying it's not really a regulation that's based on content. On the other hand, he's talking a lot about how bad the content is and rejected the plaintiff's case. So I found this incredibly curious and odd as a bit of First Amendment analysis. And also, by the way, out of step. Every other district court that has looked at one of these drag queen prohibitions has struck it down, and it's happened multiple times. We stopped covering it on AO. It was so common. It's like, another court struck down a drag show ban.